In the winter of 1457, in a small village in the east of France, a mother was arrested for murder. She was dragged to prison, held for a month, and then brought before a judge in a proper court of law. There were lawyers for the prosecution and the defence. There were 9 sworn witnesses. The evidence was weighed, the law was consulted, and a verdict was reached. She was found guilty, and she was sentenced to hang. The mother on trial that day was a pig, and this was no joke and no isolated madness. For hundreds of years across Europe, animals were arrested, tried in real courts, defended by real lawyers, and executed for their crimes. This is the strange and true story of the medieval animal trials. The case in 1457 took place in the village of Savigny in Burgundy. A sow and her 6 young piglets had attacked and killed a 5-year-old boy named Johann Martin. When they were found, the piglets were spattered with blood. All 7 animals were seized, along with their owner, a man named Johann Bailly, and thrown into the same cells that would have held any human suspect. A month later, they were put on trial. And it was a real trial, conducted with complete seriousness. A judge presided. Lawyers argued the case. Witnesses were called by name and gave their testimony. The owner, Bailey, was accused only of negligence, of failing to keep his animals under control, and in the end he was not punished at all. Responsibility for the killing, the court decided, lay squarely with the pig. After consulting men learned in local law, the judge sentenced the sow to death. She was to be hanged by her hind legs from a gibbet in the custom of Burgundy, and the sentence was carried out by the public executioner in the village square. The 6 piglets were a different matter. They too had been charged as accomplices, and they had been found covered in the child's blood. But no one could prove they had actually taken part in the killing. And so, partly for want of evidence, and partly, the record says, because they were young and had merely been led astray by the bad example of their mother, the piglets were acquitted and released on a promise of good behaviour. It sounds like something invented, but it happened again and again. Pigs, above all, filled the dock. To understand why, you have to forget the fat, slow, pink animal of today. The medieval pig was closer to a wild boar, lean, fast, powerful and aggressive, and it was left to roam the lanes and yards of the village more or less at will. It would eat almost anything it found, and in crowded households where infants were often left unattended, it sometimes found a child. Pigs, the records show, were responsible for the deaths of a great many babies, and so pigs, more than any other creature, found themselves on trial for murder. One of the most infamous cases came from Falaise in Normandy in 1386. There, a sow was convicted of savaging an infant in its cradle. Her punishment was designed to mirror the injuries she had caused. She was to be maimed in the head and the forelegs. And then, in a detail that captures the whole strange spirit of the thing, she was dressed in a jacket and breeches, like a man, and hanged from the gallows in the market square. A painting of the scene was made on the wall of the local church, and survived there for 400 years. A receipt still exists for the executioner's fee. And like any hangman who had put a person to death, he was given a fresh pair of gloves afterward, so that he might walk away, symbolically at least, with clean hands, having taken a life but carried no guilt for it. Because that is the crucial thing to understand. None of this was done as a joke or a game. It was justice, carried out with painstaking care. More than 100 such cases are recorded, from the 9th century right through to the 18th. Most of them in France, though they reached into Germany, Italy, Switzerland and beyond. Judges, lawyers, Court officials and executioners were all paid their ordinary wages for their work. Some animals were hanged, some were burned at the stake, as a pig was at Fontenay in the 13th century. One at Saint-Quentin was buried alive. On another occasion, a hangman travelled 50 miles from Paris to a village that had none of its own, simply to do justice to a single guilty sow. In the 19th century, an American scholar named Edward Payson Evans spent years in the archives of Europe reading trial records, parish accounts, and dusty legal notebooks, and he uncovered hundreds of these cases, a whole forgotten machinery of law turned against the beasts. And it grew stranger still. The larger animals, the pigs and cows and horses and dogs, went before the ordinary criminal courts, the same courts that tried men. But the small creatures, the rats and mice, the locusts, weevils, caterpillars and snails that destroyed a village's crops, were something else, and they were tried instead by the courts of the church. Since you could hardly arrest a swarm of rats, the church would summon them by proclamation, appoint them a defense lawyer, and if they failed to appear, would curse and excommunicate them from a distance. The most celebrated of these cases produced one of the great legal performances of the age. In the French town of Autumn, the rats were accused of devouring the barley crop, and their defence was entrusted to a sharp young lawyer named Bartholomew Chassenet. When his clients failed to turn up to court, Chassenet did not concede. He argued first that a single summons was unfair, since the rats were spread across so many villages that one announcement could not possibly reach them all. When that was answered, he argued that his clients would gladly attend, but simply could not, because the roads between their homes and the courthouse were lined with cats, and no rat could be expected to risk its life to answer a summons. The court was forced to take the point seriously. Chassenet won his reputation defending vermin, and went on to become one of the most respected judges in all of France. Not every animal was condemned either. In one case, a female donkey accused alongside her owner was acquitted outright, after a string of witnesses came forward to testify to her gentle nature and her good character. And in Basel, in 1474, a cockerel was solemnly put on trial and burned at the stake for the unnatural crime of laying an egg, which people feared might hatch into a monstrous serpent. So why did they do it? Not, as later ages sneered, because they were simply stupid. The medieval world took its scripture seriously, and scripture said that God would demand a reckoning from every beast that shed the blood of a man. An animal that killed a child had broken a sacred order, and to let that pass was unthinkable. Some argued the trials served as a warning, though not to the animals, of course, who could hardly be deterred, but to careless parents, reminding them never to leave a child alone. Others, more cynical, suspected the whole business was a way for local lords to raise money through their courts, though since the animal was usually destroyed, there was rarely anything left to seize, and the trials generally cost more than they made. But there was something deeper than any of these. Life was precarious and frightening, and a pig really could kill your child in the time it took to turn your back. The trial, the summons, the verdict, and the sentence gave people a way to answer that terror, to take something senseless and cruel and force it into the shape of order and justice. It let a grieving village feel that the world still made sense, that even a pig must answer for what it had done. The animal trials faded as that world changed, and later historians looked back on them with embarrassment, struggling to understand how anyone could ever have believed in them at all. But perhaps they teach us something simpler, that every age is certain that its own justice is sound, and that one century's solemn court of law can become another century's strange tale of a pig that was hanged for murder.